Good morning, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. Excuse me, let me adjust this real quick. All right, folks, just a few short things before we get going this morning. First off, for the document we are now going through, as well as the Shut the Judge Rotenberg Center Down Change.org petition, and the video that kicked off all the rest of the videos on this channel on the JRC, please click on the description box and you will find everything there. Also, real quick, when we are talking about the JRC, we are talking about some very vivid descriptions of tortured disabled people. So, if you have young ones present, please make sure to go ahead and wear your headphones while you are watching these particular videos on the channel. If I happen to horribly mangle any legal terms or trip over my words because it's just simply too goddamn early, please forgive me in advance. All right, folks, without further ado, we are back on the documents for the Judge Rotenberg Education Center, Inc. versus the U.S. Food and Drug Administration. We are starting Section B, the Plaintiff's FOIA request, Freedom of Information Act, by the way, if you don't know the acronym. Nearly 3 months after the FDA published a proposed ban, Peterson submitted, on July 19, 2016, 6 identical FOIA requests to the FDA and 5 FDA components first request. Defendant's statement of material facts to which there is no genuine issue. Citing I won't read that out loud. The first request asked for records about, among other things, FDA's inspections of the JRC, the Neurological Devices Panel of Medical Devices Advisory Committee, and the FDA's proposed ban of electrical stimulation devices. The FDA, consistent with internal regulations, consolidated these requests for processing. First, declare of Sarah Kotler, Division of Freedom of Information. Peterson sent 2 additional FOIA requests to the FDA on August 23, 2016. One of these requests sought, among other things, records dating back to 2012 of the meetings between FDA employees and stakeholders in the electrical stimulation devices. Oh, Jesus Christ, really? Of communications between the FDA and other divisions of the HHS about electrical stimulation devices. So what you're trying to figure out is if this is motivated by money or if there's greasing palms just because they want to ban a device that is proven to cause extreme physical long-term harm. Okay, Karen. Or Chad, or what the hell ever. Of literature analyzing electrical stimulation devices that the FDA received or created, and of communication or records between FDA employees and former patients of the JRC. Oh my God, is this AH's lawyers doing? Because it's the same word salad. The other requests sought materials related to expert opinions from 3 individuals about electrical stimulation devices. You mean your experts, your biased experts on your payroll, but you want to say the FDA is biased. Okay. You really want to open that door, JRC? Finally, on December 27th, 2016, JRC submitted a letter that the FDA treated as a FOIA request in which the JRC sought information related to statements made in the FDA's Federal Register notice announcing a proposed ban on electrical stimulation devices. The Parents Association sent a letter on February 27th, 2017, joining the 4th request. I swear to God, if they do another version of, "You just don't understand. It's the only thing that's going to help these kids. They're going to kill themselves. They're going to hurt other people." This fear-mongering bullshit. And you want to tell me you've never abused your power with those? Really? Because we got video evidence that says different. But anyways, we'll read through Section C real quick, and we'll leave the rest on for Wednesday. The FDA's processing of the plaintiff's FOIA requests. When the FDA receives an FOIA request, the FDA's Division of Freedom of Information, the unit responsible for the FOIA compliance, directs the request to the FDA components most likely to possess responsive records. DFOI is also tasked with locating any responsive records that have been previously produced in response to separate FOIA requests. After receiving the plaintiff's 4 FOIA requests, DFOI distributed the first, second, and fourth requests to 4 FDA components: the Office of Chief Counsel, the New England District Office, Division of Information Disclosure, and Office of Regulatory Affairs, so that they could search for responsive documents. In addition, 2 HHS divisions outside the FDA agreed to produce records responsive to the first, second, and fourth requests. The third request directed only to the CDRH's Division of Information. From September 2016 from July 2018, HHS and multiple FDA components produced records to the plaintiffs as summarized below. DFOI made 5 separate productions to the plaintiffs on September 7th and 28th, 2016, on February 13th, 2018, and July 2nd and 11th on 2018. In total, DFOI produced roughly 10,000 pages of redacted reports. The OCC, for its part, made 3 productions of its own records to the plaintiffs on the following dates: December 4th and 22nd, 2017, and March 5th, 2018. All told, the plaintiffs received, with redactions, a total of 2,800 pages of OCC records. Separately, the OCC produced on March 19th, June 13th, and June 18th, 2018, after consultation with the Department of Justice, redacted records that originated within the DOJ. Likewise, the OCC released on April 3rd and May 14th, 2018, after consultation with separate HHS divisions, 26 pages and 58 pages, respectively, of redacted records that originated within those divisions. Declaration of Marquis, Department of Health and Human Services. Finally, the OCC provided on February 13th, 2018, after consultation with the Department of State, redacted records originated with the state. The New England District Office too had responsive records. That office made 4 productions to the plaintiffs on the following dates: September 26th, 2016, 16 redacted pages. On May 2nd, 2018, 562 redacted pages, and on June 15th and June 20th, 2018, totaling 10,205 redacted pages. The ORMA made 2 productions of the plaintiffs on June 4th, 2018, of 10 redacted pages, and on June 29th, 2018, 372 pages of redacted records. 2 HHS divisions outside the FDA produced records to the plaintiffs beyond the records released in the consultation with the OCC. The division, the Office of the Secretary, released 756 pages of redacted records identified through internal search on June 15, 2018. The second division, the Administration for Community Living, provided the plaintiffs on June 6, 2018, with 485 pages of redacted records. In total, HHS divisions both inside and outside the FDA, but excluding the CDRH, have produced 24,241 pages of records to date. Of those pages, approximately 12,642 pages were redacted in full, and another 1,340 pages were redacted in part. So let's sum up them making me read all those numbers and dates for you real quick, folks. This is a fishing expedition. But the JRC wants to prove what they are questioning is, first of all, the FDA's right as a federal organization to be even able to request or enforce the ban on the devices in the first place, as they view it, it is a medical matter. Number two, what they are trying to show with all these demands for records is some kind of internal bias. They have been claiming for a long time that all the experts on the subject were not heard. Parent testimony was discounted and dismissed. And they have been saying that all the way back from about around the 2016 era. They want to show bias. They want to implicate the FDA as dirty, if that's what it takes. And more than all, they basically want to say that the FDA has no right to judge whether or not these devices are effective or cause harm. So, the fact that they have the balls to go against a federal agency like this is just astounding to me, folks. This is like, I can't even imagine the ego you would have to insinuate this thing, all these things about the FDA panel that issued the ban. And what I really can't comprehend is why people would fight the ban in the first place. What kind of Kool-Aid are the JRC staff giving to these parents? They would fight so hard so that those kids will continue to be tortured and tormented and denied sleep, denied food, denied basic human rights, and believe wholeheartedly that this is what's going to make them better. I don't understand why you would defend torture of disabled people that much. What's really interesting is these same parents are the ones that fight gung-ho when it would come to criminals of war if the same devices were applied to them during interrogation. But it's absolutely necessary for your son and your daughter to be forced into that kind of treatment, but you wouldn't even dare think of having it done to a war criminal? It makes no sense, folks. These kids have done nothing wrong, nothing in their lives to deserve this kind of treatment. If these parents have drank the Kool-Aid and these JRC people are just gung-ho willing to fight all the way to hell and back so that they can continue to use treatments we would not use on war criminals, on these poor kids. It makes no sense at all. But I digress. We'll go ahead and continue on with these court documents tomorrow. I do got to finish getting ready for work. Hopefully I get more than 2 sales, because yesterday, God, that was just a long nightmare of a dumpster fire. But anyways, not the point. So let's go ahead and close out, folks. As always, we don't get very many views on this channel. The few that we do tend to get removed from time to time. So if you could, folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye.